Mr. Giovanetti.
My Lords, I'm not going to be very much longer on reasonableness, and then I'll move on to the criminal deportation provisions and the question of unduly harsh and what it means. If I could just go back very briefly to the point Lord Carnworth was putting to me just before the short adjournment, and my answer, I think, would be that the rules are more, not the rules, the provisions of the Act are more prescriptive in some circumstances and are broader in others. And you just have to look at the individual provision to see what the tribunal's being directed to do. So, for example, as you may recall from MF Nigeria and Hesham Ali, one of the points the Secretary of State was concerned about was that she thought the right test was insurmountable obstacles, and the tribunal was applying a lower test. And in that context, she formulated a test of insurmountable obstacles in the rules. It followed through, and in Agiarco, this court held that when it's applied to a partner in an entry clearance case, insurmountable obstacles is indeed compatible with the convention. So there have been instances like that where the test has been modified by the test to be applied by immigration officers, modified by the rules. The rules obviously aren't binding on the tribunal, but where Parliament has set out the test. But in some circumstances, it's directed the tribunal to consider a hard-edged question, and in other circumstances, it's an evaluative question, and the extent of the evaluation and the scope for fact-finding depends on how it's formulated. So if we could just turn back to the Act itself at tab 7 of volume 1 of the authorities. I'm looking at MS page number 86. If we take exception 1, for example, the tribunal has to ask itself whether C has been lawfully resident in the UK for most of C's life. That's a pure question of fact. Yes or no. B is more evaluative. They're considering and assessing whether C is socially and culturally integrated in the United Kingdom, but a very specific question is put there. And it's directed to the position in the UK. C, there would be very significant obstacles to C's integration into the country to which C is proposed to be deported. Again, it's evaluative, but it's a very defined, focused question. And then when we look at 5...
Well, staying with 4,
yep.
Is there any room in 4 for the insinuation of a public interest inquiry?
No, and I accept that there isn't. One has to look at the language of each provision to see whether there is or there isn't. Very specific questions are set out and addressed there.
Yes.
And if A, B and C are satisfied, the appeal succeeds, and I entirely accept that. But 117C5 is asking a very different sort of question. It's asking whether the effect of deportation on the partner or child would be unduly harsh. And that is a much wider evaluative question, which doesn't direct the tribunal to specific matters, but leaves it open to the tribunal to have regard to the factors that inform the exercise it's conducting, which is, after all, an Article 8 balancing exercise. And it's the same...
That all comes in the word undue, does it?
Yes, it does. Yes.
And we want to come on.
I'm going to come on to that, and that's what I'm going to move on to in a moment. And I'd say that similarly, the question of whether something is reasonable, again, is a very broad question. So some provisions... I'm sorry, my lord.
So subsection 3, 117C3, doesn't require the court or a tribunal to carry out any balancing exercise in relation to exception 1. The balancing exercise has been carried out by Parliament and is expressed in subsection 3.
Yes.
Right? Plainly, exception 2 involves a broader an evaluation which encompasses many more factors, or may well do, than exception 1. But you say it's of it that the court is actually carrying out, or tribunal is carrying out a different kind of exercise altogether under exception 2.
Yes, it is.
And Parliament hasn't made a proportionality assessment so far as exception 2 is concerned. It's directing the court or tribunal to carry out that assessment.
It is.
That is all taken from the word unduly.
Yes, which we say is to be interpreted as unjustifiably, which directs you to look at the justification. So in relation to 4, if A, B and C are satisfied, then the outcome is mandated. In relation to 5 as well, if it's satisfied, the outcome is mandated, but 5 involves the tribunal itself determining justification. And I accept that Mr. MacDonald started his submissions yesterday by praising the sort of impeccable nature of the drafting. Well, as you've already seen, the Court of Appeals had to intervene to insert into the less than 4 years cases a provision enabling the end balancing exercise to be conducted. There are difficulties with this statutory framework. I have to accept that. But those difficulties don't, in our submission, shouldn't result in distorting the language used at least not unless it's open to more than one interpretation and only one is consistent with the purpose, which is a proper Article 8 compatible end result, which is, of course, what the purpose of this legislation is. So I say that unduly means unjustifiably. You've got to look at justification, and equally, when you're looking at what it's reasonable to expect, you have to look at the reasons for expecting it.
Well, I take it that you would accept that there is there's more than one possible connotation of unduly. It's not necessarily a synonym for unjustifiably.
Well, we've set out in our case the OED definition, and that gives unjustifiably, disproportionately, but that's what it's looking at. I appreciate that, and it's part of my case, I'd assert, I'd contend, I'd submit that it's context specific. So one of the cases we've given you as an example for reasonableness is the Holmes-Morehouse case, which my Lord Wilson in particular might be familiar with, which looks at looks at how you answer the question of whether it's reasonable to expect a child, a dependent child, to live with a parent. And it was held in that case that looking at it from the perspective of the family courts, you looked at it in a different way to looking at it from the perspective of a housing authority who was trying to determine whether to allocate scarce housing resources. So, like so many of these terms, it's important that you look at the statutory context in which the question's being posed. But here, the context is Article 8, and we say that Article 8, it's inherent in Article 8 that you conduct a balancing exercise.
What I find, I want to come on to unduly, and I'm interested to hear it, but reasonable, as you pointed out, is an expression which has been used in the context of Article 8 for years, and one finds it, so one doesn't have much difficulty with that. But it's when you're coming on to unduly harsh, I want to explain why the statute suddenly takes a phrase which has never been used in this context at all, other than in a context which is very familiar to us from asylum cases.
Yes, and that's exactly what I was going to move on to. Before I do, I wonder if I could just briefly turn, because you don't have every iteration of the instructions, the rules, the guidance, because you'd have twice the number of materials if you did. But there was something I picked up last night that I just thought was interesting and that you might find of some assistance. And it's from the case of BB decided by this court in 2015, you've got it in volume 1 of the authorities bundle at tab 22.
Page.
Oh, sorry, it's page 5065 of the hard copy and MS 293. And it's paragraph 20. Could I just ask you to look at next to letter G, the line beginning with the word margin. Exceptional means circumstances in which refusal would result in unjustifiably harsh consequences for the individual or their family. So we haven't got to unduly there, but we've moved to unjustifiably harsh. And there's a danger, I think, sometimes in trying to extrapolate between what's meant by the difference between using compelling or very compelling, or unjustifiably harsh or unduly harsh. And it may be said against me, but they've moved from unjustifiably to unduly. That shows implicitly an intention to apply the internal relocation test from asylum cases. So I'll move on to that now, if I may. And tell
Before you do,
oh, sorry.
I'm struck that one of our former colleagues had a special antipathy to looking at dictionary definitions, but I'm afraid I succumbed to the same temptation as you, and I looked at the Oxford English Dictionary. One of its connotations is excessively, and that would cast a quite different light on unduly harsh than would unjustifiably, wouldn't it?
I'm not sure I'd accept that it would, because you've got to look at what's excessive in the context, I think.
You're thrown back to what do you mean by the context?
Yes, absolutely. And so, for example, in the sentencing context...
Perhaps the antipathy was well-founded after all.
I'm not sure there's much more I can say about that, but could we perhaps go on to look at Januzzi and the approach to undue harshness in the asylum context?
Yeah.
And you've got that in Authorities Volume 2, it's at tab 30.
Page.
Oh, sorry, 28. I don't know where I got to 30.
Sorry.
Oh, sorry, MS 509.
Thank you.
Lack of sleep's beginning to tell. My apologies. It starts at 508. I was picking it up at 509. And I'm just looking at the head note at the moment, next to letter B, held. What the court was doing there was interpreting what's unduly harsh by reference to the definition of refugee in Article 1A2. And then if we pick it up under letter D, the third line down beginning with the observer lower standard, at the end of that line, accordingly, the question whether it would be reasonable or unduly harsh to expect a claimant to relocate was to be assessed by considering whether he could live a relatively normal life in the place of relocation, judged by the standards generally prevailing in his country of nationality, and could reach that place without undue hardship. The 2 points to note there. The first is that reasonableness and undue harshness are being looked at as opposite sides of the coin. And secondly, that the test is being informed by the context, because what you're looking at is whether a person is outside the country of his nationality because of, for reasons of, a well-founded fear of persecution. And as we'll see going through it, the court was saying, well, you're not outside the country of your nationality by reason of a well-founded fear of persecution if there be places in that country where you could live safely, but the living conditions aren't good there, because that's not what the Refugee Convention is intended to address. So could we turn to page 520, please, MS 520. And it's judgment of Lord Bingham, and I'm picking it up just above letter C. In fact, maybe we should pick it up a little bit earlier. Fourth line down, beginning with the word nationality. Each appellant came to the United Kingdom and here claimed asylum as a refugee. In each case, recognition as a refugee has been denied on the ground that there is another place, the place of relocation, within the country of the appellant's nationality, where he would have no well-founded fear of persecution, where the protection of that country would be available to him, and where, in all the circumstances, he could reasonably and without undue harshness be expected to live. The common issue in these appeals is whether, in judging reasonableness and undue harshness in this context, account should be taken of any disparity between the civil, political and socio-economic human rights which the appellant would enjoy under the leading international human rights conventions and covenants, and those which he would enjoy at the place of relocation. I mean, we're really a very long, long way away from Article 8 and expecting a child to accompany its parents abroad. And then just below letter...
Sorry, where does... It's not clear. I mean, he's taking undue harshness as being the test, which everyone agrees applies, but I'm not sure where it comes from. So I could see it comes from Canadian cases.
Yes, I was going to go through this in a bit of detail if I wasn't stopping there. Sorry, I was just pausing rather than stopping. And then below letter D, the line beginning the appellant's nationality, the answer to those questions must be found in the 1951 United Nations Convention relating to the status of refugees, as amended by the protocol, and in such exegesis of the convention as commands clear international acceptance. So you're looking at undue harshness, reasonableness, in the context of the instrument in particular, and whether the person qualifies as a refugee. If we move on to 522, the points made at paragraph 7, just above letter B, that the Refugee Convention doesn't expressly address this situation, but the situation may fairly be said to be covered by the causative condition, and that's what I was trying to summarise, to which reference has been made. If a person is outside the country of his nationality because he's chosen to leave that country and seek asylum in a foreign country, rather than move to a place of relocation within his own country where he'd have no well-founded fear of persecution, where the protection of his country would be available to him, and where he could reasonably be expected to relocate, it can properly be said that he's not outside the country of his nationality, owing to a well-founded fear of being persecuted for convention reasons. So you're looking at what is the underlying question and using undue harshness and reasonableness to help inform your answer to that. And then next to F, the corollary of this proposition, as is accepted, is that a person will be excluded from refugee status if, under all the circumstances, it would be reasonable to expect him to seek refuge in another part of the same country. And then we look at the derivation of the tests, and as my Lord Lord Carmouth quite rightly says, we started, I mean, it's all in, most of it's in the international case law. We have reasonableness deriving from the Canadian cases. New Zealand case laws looked at page 523, just under letter D. And then at 11, the domestic case laws picked up again, the case of Robinson, which was being relied upon by the appellants. In determining whether it would not be reasonable to expect the claimant to relocate internally, decision maker will have to consider all the circumstances of the case against the backcloth that the issue is whether the claimant's entitled to the status of a refugee. We'd say, I'm labouring the point perhaps, but that in this context, you look at all the circumstances of the case against the backcloth, that the issue is whether the parent is entitled to remain because of Article 8 of the Convention. And then at the bottom of that page, we have I think the first, although it may have cropped up earlier, but the first that I've picked up, formulation of the unduly harsh test, 2 lines below letter G, if my lord has it. And it's from the judgment of Lyndon J.A. in a Canadian case. Stated another way for clarity, would it be unduly harsh to expect this person, who's being persecuted in one part of his country, to move to another less hostile part of the country before seeking refugee status abroad? Went on to observe that while claimants shouldn't be compelled to cross battle lines or hide out in an isolated region of their country like a cave in the mountains, a desert or a jungle, it will not be enough for them to say they don't like the weather in a safe area, that they have no friends or relatives there, or that they may not be able to find suitable work there. Overleaf, we have more of an analysis of Canadian authorities, paragraph 12. Just above letter G, the line beginning appealing to the claimant, starting towards the end of that line, rather, the question is whether, given the persecution in the claimant's part of the country, it's objectively reasonable to expect him or her to seek safety in a different part of that country before seeking a haven in Canada or elsewhere. Stated another way for clarity, the question to be answered is, would it be unduly harsh to expect this person, who's being persecuted in one part of his country, to move to another less hostile part of the country before seeking refugee status abroad? On the opposite page, that's MS 526, there's a citation from Ranganathan, which begins, we read the decision of Lyndon J.A. for this court as setting up a very high threshold for the unreasonableness test. And then, overleaf at MS 527, paragraph 13, we come to the decision of the Court of Appeal here, which is the decision that was effectively upheld by the House of Lords. We see that in E, the Court of Appeal declined to adopt the Hathaway New Zealand rule. I won't read it all out to you, but
And what was the Hathaway New Zealand rule?
the Hathaway New Zealand rule was the more generous one.
So this is you accept what, as was said on the previous page, very high threshold for the unreasonableness test. Is that your case, that unduly harsh is a very high?
No,
it's not. You're going to say it doesn't.
Yeah, no, it's not. My point I'm not relying on this. I'm explaining why this is not an appropriate approach in Article 8 cases.
Yeah, which makes it very odd that it was used.
Yes, and the tribunal said, and I can see why they alighted on it. This is a phrase we recognise from the refugee context, but when you read how it's to be applied in the refugee context, I don't see how this can be applied in an Article 8 case. I'm not suggesting it can.
But anyway, so I don't need to take you off the court.
So
trying to understand what's being said.
Yeah, so if we read, I just invite you to read all of E.
And you say this has all got nothing to do with it because
no, in particular, there are bits that are so antithetical to an Article 8 exercise. Taking, for example, another bit I'd marked on the opposite page, MS 528, 3 lines above letter E. The comparison between the asylum seeker situation in this country and what it will be in the place of relocation is not relevant for this purpose. They may be very relevant when considering the impact of the Human Rights Convention or the requirements of humanity. We're not suggesting, nobody's suggesting, that the child's situation in this country is excluded from the approach under Article 8. It's the opposite. And again, overleaf at 530, paragraph 20, Lord Bingham rejects the challenge to E, dismisses the appeals, and then says that it's useful to have some guidance on the approach to reasonableness and undue harshness in this context. Valuable guidance found in the UNHCR guidelines. Paragraph 7.2a, the reasonable analysis is approached by asking, can the claimant, in the context of the country concerned, lead a relatively normal life without facing undue harshness. And again, that's picked up at the bottom of the page, just under letter H. Conditions in the area must be such that a relatively normal life can be led in the context of the country concerned. Just for completeness, at 23, Lord Nichols agrees. Sorry, that's page 532.
I mean, you've made your point, that you say this has got nothing to do with it because it's a different context. There's a point in going on.
No, what I was going to take you to was just showing that that was not an aberrant judgment. It's the agreement. So yes, that's my point on the refugee test. Then the other approach that's been suggested is that you look for something more than the usual harshness. And I just find that quite ironic in Hesham Ali, which was effectively an appeal from MF Nigeria, as the court will know, the Secretary of State was being criticised for using the word exceptional circumstances on the basis that this court had made it absolutely clear that proportionality does not involve searching for unusual or exceptional circumstances. It involves looking at everything in the round. And the Secretary of State...
I mean, that's why we're trying to find out what unduly harsh means, which is an expression which for some reason the statute is used. I mean, I was quite impressed by the way the President, McCloskey, dealt with it in a case called MK Sierra Leone, where he says over and above the usual.
Yes.
Now, that fits in with the word excessive. What's wrong with that? I mean, can we look at that? Because I think, there's someone with considerable experience of dealing with these cases, sitting with Judge Perkins, who was the judge in one of these cases. MS 1394, I think. And it's quite helpful here because he actually applies the test and finds that in one case it's met, the other it's not. This is 1394 towards the bottom, little 4. And he says the last 3 lines require something over and above the usual consequences. And he decides that's not satisfied in the case of the partner. He finds that it is satisfied in the case of the 2 children for reasons he sets out. Now it seems to me that's a perfectly possible meaning of the word unduly harsh, something over and above the normal consequences. But you're not saying that's the right test.
Well, I think it tends to narrow, or it can tend to narrow, the evaluative exercise, because we've seen decisions in the past where the tribunal said, well, I accept that it'll be devastating for these children to lose a parent, but that's the normal consequence. You've got to look at how devastating. You really have to carry out an evaluation in each case.
I mean, here's a very good example of an experienced tribunal judge doing just that.
Yeah, well, and
it seems, I think, apart from the one case of KO, it seems to be in the orthodoxy in the upper tribunal that it doesn't have your sense, it has the sense being argued for by the other side.
Firstly, could I say that the President in this case didn't suggest that he was required to disregard public interest considerations when doing this. And if we look at paragraphs 46 and 47, tribunal there considered the facts, and it said unduly raises an already elevated standard still higher. And then at 47, just picking it up on the 4th line down, once again an evaluative judgment on the part of the tribunal is required. In performing this exercise, we view everything in the round. And they then set out the factors which would tend to make the decision unduly harsh, i.e. the best interests and the impacts on the child. But then, having reminded themselves of Section 55 of the 2009 Act, they acknowledge the distinction between harsh and unduly harsh and say, we remind ourselves again of the potency of the main public interest in play. So,
It doesn't identify the main public interest in
it may not do, but in terms of this being, the decisions of the tribunal are not always as clear as they might be if one just looks at one paragraph. I would commend the approach.
At any stage in this judgment, refer to the public interest of effective immigration control.
I think that was a criminal deportation case. Because of course, in the context of unduly harsh, we're looking at criminality rather than removal on immigration control grounds. But could I commend to you?
Sorry, can I ask you, do you have any submission that that is why the expression unduly harsh is used as opposed to unreasonable, which would be the language one might have, sort of language one sees where criminality isn't involved? Is it going to be a higher or more rigorous standard?
I think that's precisely why it was used, to emphasise that, and I think everybody accepts that in criminality there is a weightier public interest, as Parliament's demonstrated by expressly legislating in that way as far back as the Section 32 of the, remind me, the 2007 Act. I'm sorry, too much legislation.
Now, if that's so, it can't mean, unduly harsh can't have the same meaning as can't reasonably be expected. If one is meant to be a more rigorous standard than the other. So it can't both mean unjustifiable or disproportionate.
Well, I don't want to dance on the head of the pin, but in my respectful submission they can, because the justification is different. Okay. The reasonableness cases, you're looking at immigration control as a justification. You're not looking at criminality. You're not looking at criminal deportation. So in both cases, you have to look at the reason why the Secretary of State has made a decision that the parent should be either removed or deported. So in both cases, you're weighing the impact on the child against the justification for the decision, but the justification isn't identical. Probably the important thing, I'm sorry, I can see I'm trying my Lord's patience, but that's...
Of course not, my Lord, is endless.
No, absolutely not. I just wasn't finding it very persuasive.
Well, yeah. Maybe that was obvious.
Patience is perhaps a euphemism for and not making headway. But
yeah, well... So I just say they both require a balancing exercise, but the elements in the public interest side of the balance are different. And maybe what's really important, and it's easy to lose sight of this, is that nobody, well, least of all us, is suggesting that the tribunal should not be weighing everything that militates in favour of the child in the balance. This is not about excluding anything from consideration. It's just about the context in which you're considering things. I think I'm almost at the end of my submissions. What I wanted to do just finally was commend to you the decision of Upper Tribunal Judge Southern, who is again an immensely experienced immigration judge, in the KO case itself, and you've got that in the core bundle. It starts at MS 2337. I'm just hoping that the reason my Lord didn't find it persuasive was because of my advocacy rather than because it's a bad point. I think it's a good point. I may not have expressed it particularly well.
You've expressed it extremely well. Especially whether it's intrinsically a good point, not
well,
that it is.
I can't make it a better point if it's not intrinsically a good point. I think it is.
We'd have to reflect on that.
So I'd ask you to pick it up at MS 2345 under the heading Discussion.
also a common experience of judges that points which may not be immediately attractive
Certainly.
become more persuasive the longer one thinks about it.
Yeah.
I shall live in hope. So at paragraph 8, Upper Tribunal Judge Southern directed himself in accordance with the Court of Appeal's suggested approaches we've seen in cases like Repair, that the framework of Part 5A provides a structured approach. We don't need to go through that structure, but if I could pick it up towards the end of that paragraph, 4 lines up from the bottom, the line beginning claim takes place. At the end of that line, he says, again, in the context of the discussion that follows, it's important to recognise that although this process takes place under the provisions of the rules, it's an assessment of a claim that removal would breach rights under Article 8 of the Convention. So that's always the context that you're looking at. I'd suggest that you read all of paragraph 8 right through to the end of the determination. It's a key determination in the KO cases. It runs through to MS 2357, but if I could just highlight some particular bits. At paragraph 15, he addresses the point that's advanced again here, that Parliament, and before that the rules, divided cases into bands, and that all you should do is look at which band of offending rather than the specifics of the case, and he explains why that would be unfair, effectively.
Which paragraph is that?
That's paragraph 15.
Thank you.
Paragraph 17, he starts dealing with unduly harsh. And overleaf on 2348, he addresses the question of whether it should be the asylum approach that's adopted. He deals with it rather more succinctly than I did, but I think he's making essentially the same points. It's a very different exercise. Then he looks at MK and BM, which are 2 presidential decisions. MK we've already looked at, but he cites another extract from BM, which again is a decision of the then President, Mr. Justice McCloskey, and I'm halfway through MS page 2349, after the words "and a little later." Balancing all the facts and factors, our conclusion is that the severity of the impact on the children's lives of the appellant's abrupt exit, with all that would flow therefrom, would be of such proportions as to be unduly harsh. So that's how the President decided the BM case. And Upper Tribunal Judge Southern says it's impossible to see how such a balancing exercise could have been conducted unless the matters speaking in the appellant's favour were balanced against a competing interest, which can only have been the public interest in the deportation of foreign criminals, which necessarily included the factors that Section 117C2 required the tribunal to have regard to. And as you'll recall, 117C2 is a provision which effectively says the more serious the offending, the greater the public interest. Paragraph 25 on the facing page, he considers the Secretary of State's Immigration Directorate instructions, which informed the approach to the rules. And at 253, he notes the guidance says this: the effect of deportation on a qualifying partner or qualifying child must be considered in the context of the foreign criminal's immigration and criminal history. The greater the public interest in deportation, the stronger the countervailing factors need to be to succeed. The impact of deportation on a partner or child can be harsh, even very harsh, without being unduly harsh, depending on the extent of the public interest in deportation and of the family life affected. And then an example is given.
Sorry, what's this document from?
It's from, you see at the beginning of paragraph 25, it was the Immigration Directorate instructions giving guidance to decision makers in Article 8 cases. And what he says is, although such guidance to decision makers cannot be determinative in matters of statutory interpretation, since this has been published by the same government department that brought the Immigration Bill to Parliament that inserted Section 117 into the 2002 Act, it might be thought likely that the guidance at least gives a good idea of what the legislation was intended to achieve.
That's a very novel approach to statutory interpretation.
I mean, I felt less timid about going to it because the court's been asking us to provide underlying guidance and...
well, no, one likes to. One's quite interested to see the background of the statute, but your department's view is what it means. We know from you, and it's not surprising that the guidance says the same thing.
So, Ms. Giovanetti, what's the date of those directorate instructions upon which the upper tribunal judge relies?
I'll find out and we'll send a note to the court if we may. I'm so sorry, I should have looked it up before we came today. So those are the only passages, I think, I wanted to rely on in terms of the legal analysis.
Are you going to look at the factual analysis?
Well, I was just very briefly.
Because actually what I find very interesting about this is although he adopts a different approach from the President, his actual approach of looking at something beyond the normal is almost identical to that of the President.
Yes. However...
What is slightly odd is the way he deals with it when he's setting aside the public interest factor.
Well, I was about to say, yes, having commented at paragraph 44, that's MS 2356, that this family relationship was not, of course, short-lived, but the point is the same. Nothing out of the ordinary has been identified to demonstrate that in the case of this particular family, when balanced against the powerful public interest considerations in play, although the children will find separation from their father to be harsh, it will not be, in all of the circumstances, unduly harsh for them each to remain in the United Kingdom after their father is removed to Nigeria. But he thought that if he applied the approach in MAB, which is effectively the approach that Lord Justice Elias would have preferred had he not felt bound to follow... Oh, sorry. Yes. Had he not considered he was bound to follow he says that the difference in outcome would have been stark. In this appeal, he says at the bottom of the page, if there is to be no balancing exercise requiring the public interest to be weighed, and if the focus is solely upon an evaluation of the consequences and impacts upon the claimant's children, it's clear that the application of paragraph 399A can deliver only one answer, that being that it would be unduly harsh for the claimant's children to remain in the United Kingdom without their father, given that there's a close parental relationship which cannot be continued should their father be deported. And I suppose in a way we come full circle to the beginning of my submissions this morning, which is that if the starting point is best interests, they don't need to be very weighty best interests.
That wouldn't have been the President's view. He would have said, well, that's nothing out of the ordinary.
No, I don't think MAB was a presidential decision. But
it wasn't, no.
No, but it for
going back to...
Yeah. Until the matter reached the Court of Appeal, I haven't taken you to them all because I don't want to enter into a sort of battle of the tribunal decisions, but effectively there were two lines of decisions, one following this and one following MAB that said you just focus on the children and you don't take the public interest into account.
But I mean, you are saying that if we're against you on the law under section 117C, nonetheless, this is not an adequate treatment of it.
Yes, I mean, it depends on in what way you're against me. I mean, if, for example, you're against me, but you say, irrespective of there being nothing on the other side of the scales, the words unduly harsh impose a very high threshold, well, that doesn't seem consistent with this conclusion on the facts of the case.
Can we just work through that, Ms. Giovanetti? If at the end of all this, we were against you on the basic point about public interest arising at this stage of the inquiry,
yes,
then the question is, what would we do about the KO case? On the face of it, just looking at it very superficially, the upper tribunal judge has said, well, if I'm wrong on the public interest coming into it, it would be unduly harsh. But was he asking whether it was unduly harsh, whether the effect of the deportation on the child would be unduly harsh? You've just read out that his conclusion is it would be unduly harsh for the children to remain in the UK without their father.
It had already...
So that's a different unduly harshness,
well,
isn't it?
Unduly harsh considers both, whether it's unduly harsh for them to remain or unduly harsh for them to go with the father. And it had already been accepted at an earlier stage, first-tier tribunal stage, I think, that the children couldn't be expected to go with the father, not least because there was a 17-year-old daughter from a previous marriage who was well settled here. KO's counsel here, but I see they're nodding in agreement with me. I don't want to misrepresent it, but in short, that was the point on the fact. So that had already been eliminated. There was no question of them being able to go to Nigeria with a father. So the focus was on whether it would be unduly harsh for them to remain when he was deported.
It is odd that 117b(6) only requires you to look at the consequences of the child leaving the United Kingdom, whereas unduly harsh contemplates both staying here without father or going with father.
Yes.
I mean, is there any logical or rational reason for the distinction that you can identify?
What I can tell you is that the matter is going to be determined by the Court of Appeal in a pending case. I'm very pleased to say I'm not instructed, and I don't want to trespass on the territory of those who are. I certainly couldn't say I was on top of the arguments, but I think it doesn't arise on the facts of these cases, so I was quite happy to sort of leave it alone, because...
No, I'm just really asking myself the question in case it's of any help on construction.
No, well, you're absolutely right, of course.
Doesn't that arise under the rules rather than the statute? The reverse of the coin, or have I missed something? I thought the rules...
Yes, I think it's the same under the rules. In terms of undue harshness, it separates them out.
You do both ways.
Yes.
I thought the statute
Yes.
doesn't.
Yeah.
But I find it terribly confusing.
Yeah.
But what are you actually saying then? I mean, I hadn't got the subtlety that you've just explained to my lord. In KO's case, it's accepted that children can't reasonably go to Nigeria because their sister can't go.
Yeah.
So what's the question that's left then from your perspective?
Well, the question that's left is whether the consequences of their father's deportation would be unduly harsh, given that they'll be remaining here.
I see.
In other words, whether he should remain here.
Whether he should remain
Yes, whether he should remain with them.
close to the link.
Yes.
And you say that the tribunal hasn't dealt with that adequately, do you?
Well, I say it has dealt with it adequately because its primary finding was reasonably...
But assuming even if you're wrong on the law, you say it still has to go back because... Why?
If I'm wrong on the law, I would say it has to go back because even if you don't take the public interest into account, the threshold must be a high one in criminality cases. And having said that he could find nothing unusual, it doesn't satisfy the appellant's suggested approach of you look for something more than the usual consequences, because there weren't any. And the test can't be refugee convention unduly harsh, as we've seen, because that's completely different and far removed from this context. So if you're not with me on you look for justification in the criminal deportation background, then there must be some sort of almost free-floating high threshold, but that hasn't been applied. Otherwise, effectively, any foreign national criminal with a child who's a British citizen or who's been here for a qualifying child who has a relationship with them, which of course could only be contact. You have a genuine and subsisting relationship with a child on the basis that you make some financial contribution and you see them once a month. That person would be able to evade deportation.
That it must go back is that the tribunal judge here seems to have taken it as a given that if immigration, if the public interest consequences were not taken into account, then that was the end of the argument.
Yes,
because
there's nothing on the other side of the balance.
That even if you're wrong in the law, it's not correct approach to take it as a given. You've got to look at the actual impact rather than to assume that it's going to be unduly harsh.
Well, you see, he did look at the actual impact, but he found that there was, as you've seen, sort of nothing over and above the...
Yes, but you're saying that we go back to the McCloskey test or something out of the...
Yes, yeah. So, I'd estimated 40 minutes, I've been 50. Could I just briefly see if my juniors think I've missed anything?
What do we do about Mr. Gill's case? Because I'm still very unclear what he's looking for, which he hasn't got already, which is a remittal.
I don't want to get too embroiled in the facts of Mr. Gill's case if I can avoid it, but there seemed to be a suggestion in his submissions that the matter ought to be remitted because a tribunal would look at it, even though he's now an adult.
No, but I mean, forget about the fact he's now an adult. he's got a remittal,
Yeah.
as I understand it. The tribunal have got to look at it again, and you're not resisting that. So what is there?
Well, I don't think there's
It's
anything.
not you who say there's nothing.
No, we say there's nothing left.
I think there's a case, isn't there, in the Court of Appeal, which says that the Secretary of State does have this habit, after things have gone on for a long time, perhaps not her fault, of saying, well, you can apply for something else now, so why are we bothering with this? And I think the Court of Appeal said, no, sorry, we've got to look at it and see whether the judges were right below at the time when they took their decision. So for you to say, oh, he's an adult now, so let's get on with something else.
No, I'm sorry.
That's right.
No, I wasn't saying that. I was trying to resist the submission if that was what was being made, because I didn't want it to find its way into the judgment, because obviously anything said at this level will then be leapt upon and honed as a considered decision on the law. It seemed to be suggested that if it was remitted, the tribunal would have to consider things historically as if he was still a child, so that if his appeal was allowed, the parents, even though he's an adult now, would be allowed to stay. And I don't accept that. You don't need to decide it, but there is an issue between us, I think, as to the scope of remittal. Or to the approach the tribunal should adopt on remittal, which is not for this court to determine now.
But in formal terms, he's got his order for remittal. You're not resisting it.
We're not resisting it, no.
You say there's nothing left in the case. I mean, obviously the tribunal will have to consider what the tribunal considers. But
Yes.
That's quite apart from the fact that he's now an adult.
Yes. And I'm, of course, entirely happy to take it from my Lord Wilson. There's a Court of Appeal decision saying that the approach I've suggested is inappropriate. I'm sorry, I didn't intend to take an inappropriate approach, but all I'm saying is it is actually academic, and it's academic not just because we've now popped up to say you're an adult, but also because we agreed remittal at the Court of Appeal stage. The Court of Appeal remitted it, and we're not opposing that. So,
Well, they remitted it for determination on a certain basis.
yes.
Yeah, but
Yes.
we're not here to, as I understand, we're here to deal with orders. And if the order is made which no one objects to, then it's rather difficult to see what we're supposed to be doing about it. But
I don't think I can contribute any more
anyway,
to
there
this.
we are.
Yes. Could I briefly just ask...
Yes, of
Leonard
course.
Franzen and my client? Unless my lords had any questions, those are our submissions.
Thank you very much. Mr. Pilger-Sofa?
No, thank you, Madam.
Thank you very much. Right, Mr. MacDonald.
I can stand for this amount
Oh,
of time.
well,
but,
don't feel obliged to. We're quite happy to hear you seated.
My junior, Miss Snarly Nike, when she became my junior, she was junior counsel. In between then, she has been elevated to the rank of Queen's Counsel.
Well, I'm sure we're...
And
as
I
a matter
am
of fact,
very happy.
Warm congratulations.
And I am very happy for her to do the reply on our behalf. But before I sit down, can I deal with questions which were asked about the history of the judgment in MM? I don't know if I can give you anything, but a few days after the judgment, there was a summary on Lawtel, the Daily Lawtel. And for technical reasons, however, they told me that there was no transcript available. Apparently, they couldn't download the extempore judgment at that time. So I then made my application to get permission from this court on the basis of my note and the Lawtel note that appeared in Daily Lawtel. Now, I have no idea how Lawtel got that or on what they based it. I couldn't get that answer. And the transcript eventually appeared probably about 2 or 3 weeks after I'd drafted and sent in my grounds of appeal. And I did put a note at the end of it saying that I might need to amend them, but in fact I didn't. So I can't help you any further than that.
Very well, Mr. MacDonald, thank you very much.
The second thing is that documents which were asked that we should produce are to be sent to the registry online. You can have typed copies now, but they will be sent so that they can be put onto your laptops.
Good.
There was one document that you promised to supply, and somebody has supplied it.
Yeah.
So
Yes,
that's done and dusted.
Yes, but we've had an additional request that it be put into the form of an email, so that, and that's being done.
I see. Thank you.
And may I leave Miss Knight to continue? And I think
Thank you very much.
Yes, Ms Knight.
Thank you. My Lords, I just have 4 short points in reply, if I may. One, the first point relates to the proper operation of the statutory scheme. As we've identified, we say the scheme has bright line exceptions, which are exceptions 1 and exception 2. And the other bright line, of course, is the qualifying child, which itself limits children, not all children, but qualifying children. So British citizen children or children who've lived here for 7 years. And that is the way Parliament has decided that the proportionality balance, we say, should be applied in the context in which it's given. And so in relation to, as we've identified, I think my Lord Reid identified that there is no balance in exception 1. And I think my learned friend, Ms Giovanetti, QC, accepted that there was no balance in exception 1. If there's no balance in the lawful residence exception, it makes no sense to have a statutory scheme which operates with exceptions to the principle that there should be deportation, to then have a proportionality balance or in exception 2. So that's why we say that our analysis that unduly harsh must take account of only the interests on the child, albeit to an elevated threshold, elevated from what may be otherwise described as the best interest threshold. Why that's consistent with the statutory scheme. And to that, we adopt the submissions of the EHRC and Mr Chamberlain QC in relation to his analysis of how the best interest should be factored into the unduly harsh assessment. So that's the first important point to make. The other point that may have escaped, well, may not have escaped your lordships, but just to emphasise it, that for the medium offender, deportation is for a period of 10 years. For the serious offender, deportation is permanent. And so when evaluating what is unduly harsh, the impact on the child, whether staying in the UK without the parent or going with the parent as a British citizen or a child who's been here for 7 years, is effectively going to be almost likely through a majority of the child's life. Unless they are an absolutely newborn baby. And so again, that's the context in which the unduly harsh evaluation has to be conducted. And we say that's why the unduly harsh threshold should be analysed. We say that best interest is not necessarily synonymous with unduly harsh. We don't accept the Secretary of State's position that we're applying a paramountcy threshold. It's a primary consideration. On an example, we say, of where it might be said to be in a child's best interests to go or to remain in the UK, but not necessarily unduly harsh, similar to the example that Mr Chamberlain gave, that one we had identified, was it might be in a child's best interests to be educated in the UK. The system of education, even state education to which they're entitled as a British citizen, might be in their best interests to obtain, but it might not be unduly harsh to expect them to go if they have an extended family network in the country where their parent, foreign national parent, who's committed a criminal offence originates, and to where they'd be otherwise expected to accompany. So that's an example, we say, of where the best interests and unduly harsh might not coincide, albeit that any tribunal would have to have regard to the best interest in order to reach a conclusion on unduly harsh. But obviously we emphasise that the impact has got to be the consideration on the child and the child alone, and not with regard to a wider proportionality exercise. And one of the other reasons that we say that is because in order to understand how Section 117C6 operates, which is very compelling over and above the exceptions, you have to have a logical and clearly understandable interpretation of what the exceptions are, in order to understand how persons who don't meet the exceptions, then what threshold they have to meet either as medium offenders who can't meet the exceptions, either evidentially or because they don't, for example, have lawful residence, or because they are over 4-year offenders. But unless the court is really clear that it's an evidential evaluative threshold on the impact on the child, or, for example, in Exception 1, it'll be impossible to understand how one gets into the 117C6, how that should operate compatibly with Article 8, even allowing for the NA Pakistan read down, which Lord Justice Jackson identified in the cases that I think Mr. Drabble took you to yesterday. So that's why, again, we say that it cannot import that proportionality balance. And in relation to the question of what does unduly harsh mean, my lords have been taken to the MK and MAB thresholds, and we adopt those that have been identified by the President. But we also say that the case to which my learned friend Miss Giovanetti took the court, which was the BB case, which is for your reference, Volume 1, Tab 22, Memory Stick 8283 at paragraph 20. In fact, that assists the appellant's interpretation, because what the court concluded there was that it was a cumulative assessment of all the factors. What it didn't say, the court at paragraph 22, if I might just quickly look that up at Baroness Hale, MS 294 for your lordship.
Which bundle?
Oh, sorry, Volume 1, my lord. And it's tab 22. And MS 294.
Sorry, MS?
294. It starts at 293. And this was the difference between exceptional doesn't mean unique. Exceptional means something that would result in unjustifiably harsh consequences. But in determining those consequences, the factors identified there, even on the Secretary of State's case and even on her own guidance, were factors about the family. They weren't factors about the immigration history or the offending. And what it concluded was that it should be a cumulative set of factors. And so what we say is that if there's a cumulative assessment, and that's a proper interpretation of unjustifiably harsh or unduly harsh, then that is consistent with the dictionary definition of excessive or unduly in the context that it's set out in Exception 2. The other case which, my learned friend, which both parties have referred to, and again back to the question of the relevance of unduly harsh in the context of the Refugee Convention. First of all, we say, obviously they're different statutory contexts. We have to accept that. We have to accept that the claim a refugee is making specifically excludes a comparison with the country conditions in the UK in determining that question. However, what Lord Bingham in Januzzi was identifying was that it had to be a holistic assessment of all the relevant considerations which relate to the individual and the conditions. There was nothing about a public interest factor in that case. And so if unduly harsh in the refugee context is unreasonable or particularly unreasonable, the factors all relate to the impact on the individual. It's an evaluative assessment. There's no burden of proof. In fact, that's, as the Court of Appeal recently said in SC Jamaica. So each individual tribunal has to consider all the facts and make their evaluation of whether it is or is not unduly harsh. And so similarly, that's what we're asking a tribunal to do here in the context of Exception 2. So I don't think we need to say anything more about that. It's also accepted, I think, by my learned friend that if we meet the exceptions, then the appeal succeeds. And we say that is consistent with the statutory scheme, that it benefits some people. The point my learned friend Ms. Giovanetti took the court to a moment ago was how the tribunal judge in our case, KO, said, well, it would be unfair if a 12-month offender was treated the same as an almost 4-year offender. But that's the way the scheme is drawn. There's bright line considerations. It may be said by another individual, it's unfair that I'm a 4-year offender and I'm treated more seriously than a 3-year, 9-month offender. But that's the way the scheme is drawn. And once the scheme is drawn that way, we say you're either within the exceptions or out with them. And just turning to the disposal point, because we say that the findings of fact by the upper tribunal judge based upon the original findings by the first tier tribunal. So the findings of fact are for the upper tribunal is at MS 2337. So the preserved findings of fact at 2339, paragraph 5. The respondent has a family life with his wife and children, Little Romans 1 and 2. The critical findings, genuine subsisting parental relationship with all 5 children, so that's the 17-year-old stepdaughter, and then the other children who were then aged 10 and under. It would be in best interest of the children to remain in the UK with the respondent's wife, and if they chose to leave, it would be a matter for them. It wouldn't be in the son's best interests to be separated from the father, but it wouldn't be unduly harsh to require him to live in Nigeria. The respondent's daughter would suffer if her father were to be deported, but it wouldn't be unduly harsh to require her to live in Nigeria. And there was no evidence to suggest it would be unduly harsh for the 2 younger children to live in Nigeria. But there had already been the finding of fact, as my learned friend correctly pointed out, that there was a finding that it was unduly harsh to expect the eldest daughter of the family, the stepdaughter, to live in Nigeria. And you don't find that easily in that summary of facts. It's, for my Lord's reference, the relevant passage is at MS 2371, paragraph 40. And it was because the first tier tribunal hadn't addressed the other limb of the question, whether it was unduly harsh to expect her to remain without her father. That, in fact, that was the error of law found by the first tier tribunal. So we say when this upper tribunal judge came to reach his assessment at, in the upper tribunal, paragraph 44 and 45, he says if we're right on the laws, if he's adopted the wrong approach, then he made a very clear finding at paragraph 55 that there could only be one outcome. And he did so, having identified the test in MAB, which we've looked at, and the MK threshold, which is something that's unjustifiably harsh or excessively harsh. He directed his mind to the MAB approach, which is that for which the...
Sorry, where does he do that?
At 2356, paragraph 45, my lord.
2356.
Yes, MS 2356, paragraph 45 of the upper tribunal.
So is this the line of thinking, Ms. Naik? It would be unduly harsh to expect the stepdaughter to live in Nigeria.
That's the finding, yes.
Number 1. Number 2, it therefore follows that Section 117C is engaged, exception 2.
Yes.
And the father will be entitled to live here because of that. Then one considers the other children and one asks whether it would, because he's going to remain here with the stepdaughter, whether it would be unreasonable whether it would be unduly harsh for the other children to go to Nigeria, and it wouldn't be with their father. Is that the way it's done, or have I got very confused there?
My lord, the finding is that it would be unduly harsh to expect the stepdaughter to go to live in Nigeria. That was the first tier tribunal. He didn't make a finding as to whether or not it would be unduly harsh to expect the stepdaughter to remain in the UK without her stepfather.
That finding is only half the subsection 5 analysis.
Yes, he only made half the finding. So in the upper tribunal, the preserved findings were those to which I've directed my lord. And then he reached a conclusion. He reached 2 conclusions in the alternative. The first conclusion at paragraph 44, which is if I adopt a balancing exercise, it's not unduly harsh to remain for all the children to remain, or each of the children, as he says at the bottom of paragraph 44, after their father is removed. But then he puts the alternative obiter finding. I should make it clear, if I'm wrong, in case I'm wrong to adopt the approach I do to the applicable legal framework, what would be the outcome if I'd determined it in accordance with the MAB approach, which is the non-balance approach? He says the difference is a stark one. He summarises what the approach is, unduly harsh, and he says, if there's to be no balancing exercise requiring the public interest to be weighed, the focus is solely upon the evaluation of the consequences and impact upon the claimant's children, it's clear that the application, he there talks about 399A, but can deliver, it's the same question, can deliver only one answer, that being it would be unduly harsh for the claimant's children to remain in the UK without their father, given that there is a close parental relationship which cannot be continued.
But I thought we'd more or less got to the position that the question was whether it was unduly harsh for them to go to Nigeria with their father.
It's either, but for the purpose of the deportee, one has to satisfy both limbs. Is it unduly harsh to expect the child to go with the father? And is it unduly harsh to expect them to remain without the father? That's what the rules require. The statute just uses the language of unduly harsh. It doesn't it doesn't further define both those tests.
Well, it's just the effect of the deportation on the partner or child.
That's right.
It might be because they're left behind, or it might be because they go with.
And we say on either on the facts.
But I mean, as far as assume, I mean, what he seems to be considering here is a possibility of the father going to Nigeria and the children staying here.
And yes, and you said that.
And he's asking whether that is unduly harsh.
Yes.
And he seems to be just saying, well, they've got a close parental relationship, end of story. Yeah. What he's not doing, as far as I can see, is considering the sort of test that the President had in mind, which was something out of the ordinary.
Well, my Lord, he's identified the test in paragraph 45 because he said, I've referred to the MAB test.
Yes, he's referred to it. He's applied it on his view of the law, but he doesn't seem to apply it on the MAB view of the law.
Well, my Lord.
Maybe he thinks that the ordinary consequence is that the child goes with the parent. But he's found that that's displaced in this case by one of the preserved findings of fact, that would be unduly harsh because it would be in Nigeria.
Yes. I mean, he's at paragraph 43, he's paragraph 43, he says, there's undoubtedly a close relationship between this father and his children, as one would expect with any family living together. The preserved finding is that although it wouldn't be unduly harsh for the 4 younger children to move to Nigeria, the reality of the situation is that they'll remain here. And as the family relationships cannot be maintained, there'll be a complete fracture of these family relationships. The claimant is not authorised to work. He's been able to provide financial support for the family, but his role within the household means that his wife has been able to work, which she'd find it hard or impossible if she had to care on a daily basis for the children without her husband's assistance. Thus, it is said, if he's removed, the main household income will be lost, the children will be subject to economic disadvantage. That's not an experience, he says, that is severe or bleak or excessively harsh, as like any other person settled in the UK, the claimant's wife...
President, cutting this short,
yes.
if we're with you on the main legal point, we'll have to go through this judgment for ourselves very carefully. And frankly, if there's any doubt about whether he has, and the FTT has, decided it on the right basis, then it must be remitted. Proper determination.
If the judge hasn't applied the correct and sufficiently high threshold, it would have to be remitted on the facts. And if it's remitted on the facts, we have 4 British citizen children, 2 of whom are now over 7, as opposed to 1 who was over 7 before. And we also have the stepdaughter, although she's now 20, but she's still part of the family unit. So
you've got to get home one way or the other.
We would say we get home one way or the other.
Thank you.
Yes. Thank you.
Mr. Durban.
Well, also a few very short points in reply. First of all, can I accept the invitation to address the hypothesis on which the section 117 works? This is primarily relevant to 117B6 cases, which isn't me, but nonetheless it obviously helps understand what's happening in the section as a whole. Now, in relation to working out what the hypothesis is, I respectfully adopt Mr. Chamberlain's approach, which is that it is possible to spell out of the basic statutory scheme his 3 assumptions, which are that the hypothesis is that the sorry, let me get the 3 of them. Sorry. Yes, I'm sorry, I can't read my own note. The first assumption is that leaving aside the position of the child, the parent is to be removed. I agree, can be spelled out of the basic statutory scheme. Secondly, the ordinary assumption is that the child will accompany the parents, and that's because of the structure of the statute. I'll come back to that in a moment. And thirdly, that it's not reasonable for the child to be separated from the parents because the basic concept of a qualifying child is that there will be a genuine and subsisting parental relationship. I accept and positively submit that those three assumptions can be spelled out of section 117. Can I just add something that is so obvious that it sometimes needs repeating, that if one goes to the opening words of section 117A or 1, it's axiomatic that we're dealing with a decision to be made in the context where there is an identifiable immigration decision. The issue is whether that identifiable immigration decision breaches someone's convention rights, in particular rights to respect for private and family life under Article 8, and as a result will be unlawful. That person is the person who is going to be removed and so certainly often will almost always be someone who's going to be removed, i.e. the parent. And so the question simply when one comes to 117B6, the issue is whether it would be reasonable to expect the child to leave the United Kingdom in the context of the identified immigration decision which involves the person's removal. See the opening words of 117B6. So when one asks the question about what hypothesis does one approach the issue of where the child is going, and so on, the answer is where the parent or the person claiming the parasitic right under section 117 is going to be removed as a consequence of the identified immigration decision. And in a removal case, there will be removal directions, normally, and accordingly, the issue is, is it reasonable to expect the child to leave the United Kingdom in a context where the destination is the place where the parent is going to be removed to? In other words, would the removal have an unreasonable effect on the child?
Could this arise before removal directions are given? For example, just on the refusal of leave to remain?
I think it could arise.
Because if so, one might not be sure which the country is, might one?
I completely accept that there will be contexts where this analysis is just one step too simple.
Yeah. It won't necessarily be a removal decision, will it?
No, that's right.
That's where I'm slightly jibbing at your analysis.
Well, even if I'm putting it too precisely, I think as Lord Wilson observed in the course of argument, as a matter of common sense, in the vast majority of cases, it will be absolutely clear where the parent is going.
Even if it only paves the way to a removal.
Yeah, exactly. Yeah. Yes, I mean, it may be that I've just made it one stage too simple, but you're looking at the parasitic rights of the parent, C117A1. You're asking whether that parent being a person who is not liable to deportation, see the opening words of 117B6, you're told by the statute that the public interest does not require that parent's removal in circumstances where it would not be reasonable to expect the child to leave the United Kingdom. On the basis of Mr. Chamberlain's hypothesis that the family will not be split, that means considering whether or not the child, whether or not it's reasonable to expect on that hypothesis the child to leave with the parent.
Well, how do you make the judgment whether it would be reasonable if you don't know where the child's going to go?
Well, you do know. That's subject to my Lord Briggs'.
Yeah, but that's borrowing from my Lord's example. I mean, would that mean that the decision would have to be deferred until it became clear?
No, I mean, in almost no conceivable circumstances in these sort of removal cases, you're not going to know,
Right.
as a matter of common sense or factual appreciation, that the destination of the removed parent is going to be back to his country of origin.
So as a matter of practical reality, it won't arise.
As a matter of practical reality, it won't arise, and in a very large number of foreseeable cases where there are removal directions, there will be a concrete, legal, inescapable answer to it, even if one's just in the pipeline leading up to those removal directions. You will get a pretty clear practical answer. Right. So that's the first point, and that's my contribution to the hypothesis debate. Second issue is to ask, is it effectively the rhetorical question, what intellectual exercise the Secretary of State is now calling for, on the basis that her basic submission is that the public interest has to be brought into account in some but not all of the limbs of 117B and 117C. It seemed to me at one stage that the intellectual exercise could either be identification of very compelling circumstances in the way in which Lord Justice Laws stated in MA Somalia, in the MA case, or simply some recognition that the context was, as Lord Briggs put it at one stage, a question which arose in a criminal deportation case or in a case of liability to removal under 117B. But in fact, it now appears that what the Malone friend is asking for is a direction from the court, effectively, that in 117B 6 cases and 117C 5 cases, but only in the case of exception 2, does one look at the full range of factual matters, including assessment of the individual criminality and all the circumstances that are not related or not exclusively related to the position of the child, or to the question of the undue harshness of the impact on the child. And your lordships will understand that our submission in relation to that is that that's an inconceivable reading of the statutory scheme, as we say is fortified by the fact that Malone offender has been forced to accept and does accept that in the case of exception 1 in section 117, there is no room for the public interest coming in. Therefore, as was put to her in the course of argument, the statement that the public interest varies on the criminality of the offender in the earlier provisions of section 117 doesn't apply, doesn't have any impact on exception 1. And it is a pretty extraordinary construction of the statute that it nonetheless comes back into 117C exception 2. Well, those are my first 2 points. The only final point, which we probably didn't emphasize enough in opening, is just to revert to the fact that the identity of the qualifying child is either a British citizen or someone who has lived in the United Kingdom for a continuous period of 7 years or more. In the case of the British citizen, there will, quite independently of the public interest in deporting foreign criminals, be a strong reason why there's a prima facie case, in many cases, that the child should remain in the United Kingdom, and that is precisely the attributes of citizenship and attributes of citizenship and social integration and the other matters considered by Lord Carr and Lady Hale in ZH Tanzania, in passages I think I gave your lordships the references.
Yes, well,
earlier.
we've had...
Yeah. Well, those are the 3 points I want to make.
Splendid, thank you. Mr. Gill.
My Lords, I'm grateful. I have 6 short points. First relates to the question of what is the context in which the issue under 276 ADE 14 or under 117B6 arises. As Giovanetti says, you've got to look at why the situation is being considered at all, and therefore you have to look at the public interest reason for requiring someone to be removed. It's a little bit more complicated than that. Can I just say this? It's a range of situations that could arise. First of all, under 276 ADE 14, the person may be here completely lawfully, and the child may simply be asking for an application, simply be making an application for further leave to remain on the basis I've been here for 7 years with leave, and I now want, under 276 ADE 14, indefinite leave because I qualify under this rule. There's no question of removal or anything like that. That's the first category. Secondly, or it may be that a person is an overstayer. And in such a situation, no decision has been taken against the person, but again, the person makes an application saying, I'm now in the 276 ADE 14 category, please give me leave, and the Secretary of State has to make a decision. In the case of Section 117B6, it may be that a parent's situation is being looked at in the context of other questions, but not necessarily a removal decision. Thirdly, there may be a removal decision, which the parent is actually appealing, or the child is actually appealing. And in those cases, you will have a removal decision under Section 10 of the Immigration Asylum Act 1999. Now, in relation to all of these three categories of potential scenarios in which this situation arises, and the question arises, would it be the question arises where one has to ask, would it or would it not be unreasonable to expect the child to leave the UK? Parliament has taken the view, and the Secretary of State has taken the view in the rules, that certain bright lines need to be created. Not in respect of any child, not in respect of 3-year children, 4-year children, for instance, who have only been here in this country for that length of time, but for 7-year children and British children. A special category has been created. And that point, that a special category has been created, simply has not been dealt with, I don't think, by Ms. Giovanetti. The second point that I want to make is that if the Secretary of State is right in their submissions, then one wonders why Section 117B6 was necessary at all. Essentially, what she's saying is, it's a normal Article 8 analysis with everything thrown into the pot and everything being balanced. But no, that may be so in an EV type case, EV Philippines type case, where the children were here only for about 3.5 years at the time the application was made, and was certainly not here for 7 years by the time the matter got to court. It was not a 7-year case, not a British children case. That may be so in those non-7-year, non-British children cases. It is not so in a 7-year British child case. That is why Parliament has specifically made this category, this exception. That is why Section 117B6 is structured as it is. Otherwise, there's absolutely no need for Section 117B6. The third point is this point about it would be unreasonable to expect the child to leave the to leave. I also adopt the approach that Mr. Chamberlain took in relation to this. What I say, however, is this, that the question of whether it would be unreasonable or not doesn't involve actually determining what is going to happen to the parent. What you have to do is you have to approach it the tribunal really has to ask itself this. If the parent is to be asked to leave, and go to a specific country, one assumes the child will go in the ordinary course of things. The question then is, you ask yourself, would it or would it not be reasonable to expect the child to stay in the UK without the parent? That's how Mr. Chamberlain put it, and that's how I put it. And when you put it in that way, it's but a question that is almost entirely, and I use the word almost entirely, because it may be that my primary submission may be thought by the court to go too far. It is a question that is almost entirely driven by best interest considerations. But I'm not going to labor that because I've already dealt with that. One of the reasons why I say that also is that is really what is behind 276 ADE 14. And I illustrate this by asking you to actually look at the case that Ms. Giovanetti referred to, the case of PD, which is in volume 4, tab 68, starts at page 1, MS 1402. I'm not going to take time to actually read it now, but I invite you to look at the way in which Mr. Justice McCluskey, I'm a great fan of his judgments. He gets most of these right, well, all of these right, I think. But
I'm very pleased to hear that, Mr. I shall be seeing him over the weekend.
He got right.
Even where he gets it wrong, it's only because he's having to follow other authority that is not quite right. My lords, the head note I would invite you to look at and see how he approached it. I don't have time to read that head note out now, but there are 2 points that I want to make in relation to it. Firstly, one looks at MS 1420, and you see what he quoted from IDIs as to 276 ADE 14. You see at 1420, about 2/3 of the way down, Secretary of State's own position has been in Immigration Directorate instructions that the criteria set out in 276 ADE 14 reflects the duty in Section 55, which, as we know, was put into place to reflect UNCRC Article 3. It's essentially driven by best interests. They may not be the whole content if my primary submission is not accepted, but that is essentially what is being sought to be done, to carve out a specific category. The second point that I want to make from this case is that Ms. Giovanetti referred to EV Philippines and Mr. Justice McCluskey's approach in this case. But when we look at 1412, MS 1412, paragraph 24, you see the reason why he's putting it in the way that he is putting it is because he's having to follow the approach of children following in EV Philippines. And that's in paragraph 24. So we say, as I've said before, it's not a question of asking whether the children are going to necessarily follow or not. What one does, as Mr. Justice McCluskey in fact did, despite what he says in paragraph 24 there, in this case, is to look at what would be the effect on the child, the impact on the child in terms of 117B6 and 276 ADE 14, this is set out in the head note, and then consider what is then the impact in relation to the parent. That's the right way of looking at it. My lords, the next short point is this, that on the Secretary of State's construction, there can be a difference of outcome between two similarly placed children, each one of whom may have similar levels of attachment to the United Kingdom and similar opportunities available to them in another country and so on. This is a proposition which gives rise to disparity of outcomes between similarly placed children. And we say three things. Firstly, this construction is not required by, and it is in fact inconsistent with, the opening words of section 117b6, which define what is not in the public interest. Secondly, it undermines the bright line certainty provided to children by 117b6 and 276ADE14. And thirdly, it is contrary to the idea that children should not be blamed for parental conduct or choices. See MA Pakistan, Lord Justice Elias, MS Memory Stick 906, paragraph 53. On this last point, we invite you to look at our written case at paragraphs 32 to 37, where the UNCRC and Mattison, which Mr. Chamberlain helpfully took you to, are all referred to. And the four pillars of the UNCRC, which are then referred to in our written case at paragraphs 32 to following. And this is particularly paragraph 34 on page 2857. Non-discrimination between children, ensuring their development to the maximum extent possible, and having regard to their views and so on. So the question we say is, if one applies that UNC-centered approach, the child is not bound by the consequences of the parents' actions. And the problem with taking into account as a given that the parents will have to be necessarily removed is that it infects the analysis of what is reasonable to expect the child to do by matters to do with the conduct of the parents. That's the critical point. It infects the analysis of what it is reasonable to expect the child to do with matters to do with the conduct of the parents. That is completely ruled out by the seventh principle in Zumbas, and that's Lord Justice Elias at paragraph 53 of his judgment. There are, I think, then just two remaining short points. One is that in relation to the unduly harsh, you've heard the submissions of others. It's not something that I need to say very much about. I simply invite the court to have again regard to NA Pakistan at MS 965, paragraph 30, as to the meaning of over and above.
And it doesn't arise in your case.
It doesn't arise in our case, my lords, but so I perhaps shouldn't say anything about it. But any other construction, the only thing I wanted to say was that one has to be careful of not reaching a construction contrary to Section 3 of the Human Rights Act, which actually has the effect of subverting the application of Article 8, because ultimately all this is relevant to, all this has to be fitted into an Article 8 analysis. And lastly, my lords, as to the consequences for Mr. Pereira himself, I've taken our case as read, and I'm not going to go over it, but I would invite your lordships to look at that with some care, particularly at MS 2873 at paragraphs 81 to 82. And this ties in with the points that I started off my reply on. As I said, there can be situations where somebody's been here lawfully and simply asking for further leave to remain under 276 ADE14 to say, I've been here 7 years as a child. I'm actually 16 or 17. I'm perfectly happy to stay here without my parents because maybe I'm at boarding school or something like that. And in such a case, where a person has been here lawfully, what is going to be the outcome? The applicant, Mr. Pereira, was here lawfully for at least 7 years. We've explained this at paragraphs 81 and 82 of our written case, and if those relevant facts are taken into account, there can be only one outcome, but, my lords, if it still requires an analysis, then I'm certainly content to have it remitted back on the basis of the approach adopted by Lord Justice Elias. My lords, those are my points in reply.
Can I just take you back? You mentioned a case called PD and the Secretary of State, which I hadn't sort of picked up before. And you said that Miss Giovanetti had said something about it, did you? Or?
Well, she referred to it by saying that that Mr. Justice McCluskey, if I understood her submissions right, adopted a similar approach to the approach adopted in EV. And what I was seeking to do was to explain why Mr. Justice McCluskey adopted that approach by taking it to paragraph 24.
Not sure.
Well, I was wondering whether to go to PD. Ms Giovanetti mentioned it in the context of some remarks by Lord Justice Elias about the need to look at the parents together with the children. I agree with Mr Gill that if you actually go through PD carefully, it's an approach which is entirely consistent with the approach on the appellant, from the appellants.
Well, it's one would expect it as it comes from the President McCluskey, but I wasn't quite sure whether it was being suggested that Ms Giovanetti was saying PD was good law or bad law. I'm assuming she's saying it's not good law.
Well, my lord, I was simply...
Well, sorry, could I just ask
Yes,
Ms Giovanetti if you could just say whether we should look at PD and with what purpose?
Saying about PD now. I've lost my note.
It's volume 4, 1402, tab 68. And on a quick glance, it seemed to introduce a new concept altogether, which is of allowing an appeal outside the rules. But
I think all I did was point you to paragraph 40, which says application of the reasonableness test involves a balance of all material facts and considerations.
yes,
Point out that Upper Tribunal Judge Southern says, well, if you're conducting a balance, there's got to be something on both sides of the scales.
are you saying that this is a good guide to the proper approach, this case?
I'm saying a balance is. I'm not saying the entirety of the.
Well, there's no point in looking at it just for one phrase where he says a balance. I mean, that's not very helpful.
Well,
if you're
sorry,
saying we
it's not
should
very
forget
helpful.
about it.
That's what I was relying on it for, the fact that he took a balancing approach.
I'm sure you can find plenty of judges who said that.
Well,
Anyway, the net effect is we don't need to waste time on
no,
PD.
I think it was just being suggested that the President, who Lord Kerr will be seeing shortly, I'm sure you can clarify, had never adopted a balancing approach.
I've
And I think it's not
absolutely no
entirely
intention of asking him.
suggested.
Right. That's Mr. Gill. That's all you want to say?
my lord, yes. That's
Yes. Okay. Mr. Knafler, please.
Well, my lords, I have a short point and a very short point. The short point comes back to the overarching question: what was Parliament trying to achieve? And my learned friend, Ms Giovanetti, as I understood her, submitted that the function of Part 5A, or certainly the main function of Part 5A, was to restate the law. And I take her point that aspects of Part 5A simply do that, and one could say 117B1 to 5 amount to codification of aspects of Article 8. But the cases I drew attention to this morning of Satinder Kaur and Agyarko talk about an increasing tendency towards codification and also prescription, Satinder Kaur, and increased certainty and predictability, Agyarko. And the fact that parts of Part 5A could be regarded as codification doesn't mean that other parts couldn't be regarded as forms of prescription. And the question for the court, in my respectful submission, is whether in section 117b(6) and 117c, Parliament is going further than in other parts of 5a and is producing specific tests designed to require predictable results within a narrow band, and that's essentially our submission. My very short submission is really just almost by way of an apology for completely getting muddled up in response to one of the questions that was being asked of me this morning in terms of how you see the parent and the child in the context of 117b(6). Of course, I adopt my learned friend Mr. Martin Chamberlain's approach. To put it in a sentence, one would be, as a tribunal, assessing the impact on the child of leaving the UK with the child's family. And it's as simple as that. But with one twist, the destination, that will be the country of removal or the country of likely removal. Yeah. If there is any dispute about that, the Home Office will have a view and the tribunal can make a decision about where removal would be likely to occur. But that would only be in quite an unusual case. So those are my two submissions, unless there's anything I can assist further with.
Mr. Naffler, did I not ask you about disposal? And didn't you say, well, I'm not sure what the position is, we'll leave that for the time being? I'm not sure. It's so easy to get muddled between these cases. I'm not sure that Mr. Giovanetti has addressed us on disposal in your case.
No.
And you haven't either.
Well, there have been discussions between us about it, which I felt a little bit difficult to talk about. I mean, I believe the Secretary of State wants to have a look at the judgment and will then take a view on what ought to be done.
Clearly, if the Court of Appeal was wrong, then the Court of Appeal's order has got to be set aside. But then one goes down to what the upper tribunal said.
Yeah.
And the case against you is that the upper tribunal talked about best interests,
yes, but didn't
actually focus on the question, in which case it had all better be done again. Well, so, I mean, what are we to do about that? It doesn't help us in crafting our judgments to know that there are certain discussions going on.
No. Well, my submission about that is essentially the submission I made at the outset, that the judge in the upper tribunal did only address the best interest test, and he concluded resoundingly that it was in the best interest of the children to remain. On our own case, that's not the right test. He should have asked whether it's reasonable for the children to leave. But the submission I was endeavouring to make yesterday, just before my Lord's rose, is that he did assess the children's circumstances very carefully. And as a matter of fact, he just didn't identify any factor that could rationally ground a conclusion that it was reasonable for the children to leave. And if one thinks about it, these are children who were aged, the qualifying children were aged 12 at the time, and had been in the UK for 10 years, in one case 12 years since birth in the other case, who, as the upper tribunal judge accepted, were completely integrated socially and educationally, who either had no ability to communicate in Sinhala, or any very limited ability, and were, he didn't put it like this, but I put it like this, were for all practical purposes to be equated with British children who had lived here in effect the entirety of their lives, and they were then at a critical stage, being 12. They're now obviously somewhat older. So it could be remitted, but in my respectful submission, there is nothing in the careful analysis of the upper tribunal judge that could support a conclusion that it would be reasonable for the children to leave. And on these facts, a remittal would be completely pointless because it could only go one way.
Thank you.
Thank you.
Has Mr. Drabble addressed us on disposal? Mr. Drabble, have you addressed us on disposal?
I haven't addressed you on disposal. It's covered in our case. There were no oral submissions from the Secretary of State on disposal. The position is that, at least on the face of it, the tribunal judge referred to an unduly harsh test and identified particularly consequences that went over and beyond the consequences of deportation, admittedly in a short, I think, 3 series of paragraphs. There's no countervailing oral submission, and the fundamental reason why the Court of Appeal made the order to remit was the direction on the construction of the statute. Yeah. So we simply stand by
he got it
our
right.
case.
And you may have got a slightly generous decision. But you
Well,
got
exactly. No, I wouldn't demur from that. We may, but we have set out reasonably carefully but shortly in the printed case why there is no error of law in that reasonably generous decision. And as I can only repeat, no oral submission to the reverse. There is, I think, the hint of a submission that the analysis wasn't rigorous enough or something of that sort. But we say there's no underlying error of law.
Thank you.
Ms. Giovanetti, are you happy to abide your lack of oral submission? Sorry, your absence of oral submission?
Yes, I think so. We're just checking our case, but I can say in relation to Mr. Knafler's case, I mean, it's very plain, as I think he accepts, that the order would be for remission, but depending on the content of your Lordship's judgment, if there is an error of law, we're conscious of the fact that there were reasonably comprehensive findings of fact, and it might be that the Secretary of State would be minded to make a decision herself, a new decision, to avoid it having to be remitted. But that doesn't follow as a matter of course. So we've just been trying to find a practicable way forward, but we can't do it until we know the outcome. Yeah. Remittal would be the obvious, logical
we would remit, but you
consequence.
might short
Precisely, yes. Yeah.
Good. Well, thank you all very much.
Could I don't want to make a submission, but I was asked for a date, which was the date for the policy referred to by Tribunal Judge Southern, and it's very helpfully been provided for me. Could I give it to you now?
Yes, please.
What page were we looking at?
We were looking at MS 2350. That's page 87 in the KO core volume. It's the instruction set out at paragraph 25, and I'm told that this guidance was issued on the 28th of July 2014.
Oh, thank you.
So quite shortly after the Act.
They both came into existence on the same day.
Yeah. Well, we're still very grateful to Council for all their submissions and to those who have contributed to the written materials before us. It's an extremely important case, a series of cases, and we'll take time to consider our judgment. Court is now adjourned.